the trial is supposed to take. And the court went on a short recess and came back with this ruling, which talks about the fact that the application did not meet the relevancy requirement and that it was not relevant for the purposes of the determination of the case. And the specific issue of the citing of the previous election petition where interrogatories were allowed, the court essentially distinguished that from now in the sense that we have a new legal regime in the form of the amendment to the Supreme Court rules that sets specific timelines for the dispensation of the election petition. And so, for instance, even amendments are not supposed to be granted, but like we said the other time, the court felt that in the interest of justice, it would give the petitioner the opportunity to amend their petition when, technically speaking, it shouldn't have been allowed. So they made that distinction and then dismissed the application as not meeting the threshold for them to be able to grant it.
Right, and so just this morning, the NDC, as we all know now, has filed to review that particular ruling. What does that mean? Is it challenging the ruling?
I mean, when you want a review of a ruling that has been given, you can make that application or request. Whether or not it will be granted is a different issue altogether. We saw the Supreme Court rising to consider, once they have the application before them, to consider the merits of the application for review itself. But one point that we need to point out for people to understand is that according to Rule 71B of CI 16 as amended, even review applications to review the decision of the Supreme Court in an election petition is no longer entertained. So that's for the general petition itself, that there will be no review for that purpose. But as to whether this particular application for the grant of review of the ruling that was given yesterday, whether or not it will be granted, we should wait and see what the Supreme Court comes out with. So
there's a possibility that this one too would be dismissed because, as I said, it is not permitted in the first place.
No, I said the 71B talks generally about the petition itself. That an application, you know, sometimes in certain categories of cases, you can apply for review in terms of the decision if you're dissatisfied with the decision of the Supreme Court, for the Supreme Court itself to review its decision. You will remember that in the 2012 election petition, after the decision was handed out, the then candidate Nana Akufo-Addo made a statement telling everyone that he was not going to file for a review of the decision so that the country can move on. It was allowed then, but according to the rules that we have now, review applications of the decision of the Supreme Court in an election petition are no longer entertained. But so there's a distinction. So as to whether the application for the review of the ruling of the court on the matter of the interrogatories yesterday, whether that will be allowed is something that we have to wait to see. We cannot speculate as to how the Supreme Court is going to deal with this particular matter.
All right. Also, this morning, the NDC has filed another motion for discoveries. They want original coalition pink sheets from the constituency, from the regional and the national level. As George said, pointed out, these are matters in the main petition. Why does the NDC want to, get into the matter even before it starts?
Because generally speaking, mutual discovery is generally allowed prior to the trial proper. So it's possible that and discovery, when we talk about discovery, it's a question of or inspecting of documents that may be in the possession or are in the possession of a party to the dispute, and those documents may be relevant for the purposes of dispensing with the matter at hand. So it's possible that both parties may, or many different parties to a dispute may have certain documents in their possession that it will be necessary for the purposes of doing justice and for the purposes of expediting the whole process to make available to the other party for inspection, for instance, so that the matter can be or it can move on smoothly. And so, generally speaking, mutual discovery is permissible, but once again, we saw yesterday that when the motion for interrogatories, which is also another process that is generally allowed in civil proceedings, for instance, we saw that the court did not grant that application, but that is not in any way a suggestion that this may go the same way. As I always say, we should avoid speculating as to the specifics or what exactly the Supreme Court may or may not do. We should wait for them to come up with their ruling, and then we'll be in a better position to appreciate, just like how you read the ruling that they gave yesterday, which is now a public document, and we are able to appreciate and understand the reasons why they gave for dismissing that application. So we'll have to wait and see what the court decides in respect to that particular application.
All right, Doc, help us to understand this concerning time and also concerning the 42 days given. I mean, there was a ruling yesterday. There's been an application filed for a review of that ruling this morning, and another one too that was also done this morning. How does that affect the 42 days and also concerning time in this whole case?
I mean, technically, reading the Supreme Court rules, it shouldn't necessarily affect the time frame within which the court has to dispense of this matter, because we know, for instance, that the rules provide that within 21 days after the declaration of the results, a petition must be filed. That's if you're dissatisfied or you want to challenge the validity of the election of the president. That has been done as of 30th December 2020. We also know that subsequently, within 10 days from the date of service of the petition on the respective respondents, that they have to file their answers or respectively to the petition. And once that is done, within 2 days of the filing of those answers, there's pre-trial that's supposed to be conducted, and then the actual hearing takes place and lasts approximately 6 days from the end of the pre-trial hearing, within which after which, I mean, that the Supreme Court is supposed to determine the matter no later than 15 days after examination of witnesses, etc. So by the 42nd day, according to the rules, by the 42nd day after the filing of the petition, judgment should have been rendered on the election petition as a whole. So generally speaking, from my understanding of the rules, or from the reading of the Supreme Court rules, I do not necessarily feel that the time frame. We saw the Chief Justice yesterday in the ruling. I mean, talk about the fact that there's a new legal regime that gives the dispensation of an election petition to be done within a certain specific time frame. So it is the hope and belief that that is what will be done. I mean, I could be wrong, and I mean, it will all be speculation now. We should just wait to see how it plays out. But from the reading of the rules and from the rules itself, it should be dispensed with by the 42nd day.
And still within the rules, that this whole case is supposed to be determined within 42 days, there can't be any presumption of delay, can they?
What do you mean by presumption of delay?
Delay in the sense that someone is deliberately delaying the entire process with the various applications being filed and motions being filed.
I mean, it's so the Supreme Court will deal with these matters as and when they come up, and will give the appropriate directions so that the matter is dealt with. For instance, yesterday we saw that after the ruling was given on the interrogatories matter, the court went on to further direct the parties to the petition to make sure that they file their memorandum of issues by this morning, which I believe that the parties may have done by now. I know for a fact that the second respondent has filed his memorandum of issues, but I believe that the other parties have complied with the Supreme Court's direction in that regard as well. So, I mean, it will be up to the court to regulate the procedure, and that's what this whole case management pre-trial is meant for, to set the ground rules, to ensure that everyone is clear in their minds how the hearing is going to take place, the mode of examining witnesses, for instance, and things of that nature, so that the trial is expedited and we're able to get to a decision within the time frame stipulated by the Supreme Court rules, CI 16 amended by CI 74 and subsequently by CI 99.
Now, with these two new applications filed by the petitioners, does it also form part of the pre-trial issues or case management issues?
I mean, they are applications that the petitioner wants the court to consider, which they believe, as yesterday counsel for the petitioner suggested, that far from trying to delay the processes that they are filing are rather going to expedite the hearing of the matter. So it's up to the court to determine whether or not these applications are delaying the process, and that's what, like I said, the whole case management pre-trial is all about, for the court to set the ground rules to ensure that everyone is clear in their mind. So I believe that once the court comes back from recess, we will have a clearer sense of how this whole process will go.
Just on the side, I mean, you're a lawyer, and I'm sure you're also practicing, you're also a lecturer too in law. In handling someone's case, do you consider the procedure in which you would like to handle the case? I'm referring to strategies in which you like to actually adjudicate the case. Do you put all those things into consideration before you go to court?
So as a lawyer, you have certain duties that you owe your profession, you owe your client, you owe the court, and you owe the public generally. So some of the duties that you owe your client include prosecuting their agenda in the best way possible. So the best interest of the client is what is of paramount interest. And so it's not as though, and you take instructions from your client, generally speaking, but it's not up to the client to necessarily determine how to do your job, because you are the professional and you know how to do your job. And so it's not the case that the client will or should tell you how to go about doing your job, even if the client is even a lawyer himself. And so it really depends, but you must understand that you owe a duty to the court itself. So, for instance, you do not take frivolous applications or vexatious cases to the court. You owe a duty to the court to ensure that the right processes, that you do the right things, follow the right procedure, and things of that sort, and all that. So there are a number of things that you must consider in dealing with cases generally.
So, I mean, there's a game plan that you have in moving into court. I mean, from what you're saying, as a lawyer, you always have a game plan.
Of course, you need to have your strategy, know how you're going to go about your case, know probably anticipate some of the arguments that the other party may definitely want to bring out or will bring out, so as to be able to counter it. It's like always anticipating what will be done and trying to find answers for those things before they even come up, which prepares you appropriately for the D-Day. So yes, you must, or most often have a strategy in dealing with cases, but there isn't a one-size-fits-all plan that applies for all cases. There are many different types of cases. For instance, a strategy or process that you will adopt or you would want to use in prosecuting, not prosecuting, in dealing with a civil case, say involving a land dispute, will definitely be different from that which you will adopt if you are defending someone, for instance, who has been accused with and charged with the commission of a criminal offense. So it really depends on the type of case that you have. That will determine what plan or strategy that you would have to put together in pursuing that agenda.
All right, let's go back to what we were talking about before we had to go to the Supreme Court for the hearing concerning the case management of the pre-trial. You said that you know that a second respondent has actually found out issues to look out for. My question is that which of the issues becomes prominent, in the sense that it's the petitioner's case? So shouldn't it be the petitioner's role to really bring out these issues within the pre-trial, and maybe the respondents will just address those issues raised by the petitioners?
I mean, they are all parties to the petition. So like the court rightly pointed out yesterday and instructed all the parties, they were supposed to file their memorandum of issues today. The court didn't say just the petitioner should file their memorandum of issues. The point is, and we made this point earlier on, that depending on the perspective of the various parties to the dispute, their issues may not necessarily be the same, but it will be up to the court to synthesize these issues, or the many different issues that would be raised by the various parties, and come out with a definite set of legal issues that the court believes that upon all the issues that have been filed by all the parties to the dispute, that these are the 3, 4, 5 or whatever number of issues that it believes is relevant for the proper dispensation of justice in that particular matter.
Okay, all right. We'll leave it off for here, and we'll get back to you when maybe finally before. Finally, just Morris.
Doc, so after both sides have filed their issues and the court has, as you said, putting them together beautifully, would there be an opportunity for a review if any of the parties feel that their main issues were not captured, by the court?
I didn't hear part of what you said. And I'm saying
that after the two parties have brought up their issues for redress, and the EC has put in these issues from both sides together, would there be an opportunity for a review if any of the two parties feel that maybe one of their major concern was not captured in the process?
I mean, at the end of the day, the courts are there to do justice. So the court, in its own wisdom, is the appropriate not party in the sense of parties to the dispute, but the court is the appropriate authority to determine that these are the issues that will be relevant, the resolution of which will lead to justice being dispensed in that particular case. So whatever issues the court finally decides on, those issues, I believe, will be the relevant legal issues that are in play that need to be resolved for the proper resolution of the matter. So at the end of the day, it will be up to the court to decide which issues amongst all the issues that would be filed by the various parties to the dispute are relevant and go directly to the core of the matter at hand.
All right. Also, in the spirit of time, yesterday we realized that just after the Supreme Court heard the motion by the petitioners, it's adjourned to today. Are we likely to see daily sit-ins so that we're able to finish this case on time? Is it going to be a daily something?
I can't speculate on that. The only thing I can say is the fact that the hearing of the case proper is supposed to last for 6 days. Whether that will be 6 continuous days, we are yet to see. We would have to wait to hear what the Supreme Court has to say in that regard. But I believe that by the time the whole case management pre-trial process is over, we will have a clear understanding of what is actually going to happen and the timelines within which the matter will be dispensed with.
Doc, on a normal day, usual day where there are no applications, during pre-trial and case management issues, how long does it take for that period to be elapsed?
There isn't necessarily any specific time frame with some of these things. It varies, and it will depend generally.
So it can go more than 2 days?
I mean, I don't want to speculate.
we are just speaking in general terms. Sure. I mean, not necessarily to what's happening in the Supreme Court. Just have an idea.
So yes, it depends. It depends on the type of case at hand. Like I said, no 2 cases are the same, even if it deals with similar issues, because they could border on different aspects of the law. So it depends on the type of claim or the type of claims involved in that particular instance, the court within which the matter is being held, and things of that sort. So it really varies. So it's difficult to give a specific time frame within which some of these things are handled. With commercial disputes, we have the commercial court that is supposed to expedite commercial disputes, for instance, that gives certain timelines within which matters are supposed to be dispensed with. So it really varies from case to case, and the types of jurisdictions that the various courts have in dealing with certain types of cases.
All right, so with the various applications being filed, has it got what it takes to stretch the pre-trial period or the case management period?
Has it got what?
Has it got what it takes? That would it stretch the pre-trial period or the case management period? Would it stretch it with the various applications being filed?
I mean, it's difficult to tell right now, because yesterday we saw what happened in court yesterday, and we saw that the court gave the order or the instruction to the various parties that they should file their memorandum of issues today, which was what we were expecting today. But we've seen that today application for review of the ruling has been filed, which the court is studying to be able to come out with a ruling possibly on that particular matter. So it really depends. I can't really speculate on whether or not this is going to drag the process and whether or not it's going to affect the timelines. But we would have to wait and see what the court decides and how. By the time the case management pre-trial is over, we should have a clear sense of the specific timelines and whether or not we're going to meet this 42-day period that has been provided for in the Supreme Court rules.
All right, Doc, just on the side, yesterday after the entire process, on my way home, there's a gentleman in my neighborhood who asked me a question. He wanted to find out why the judges have to actually rise at every presentation made by the lawyers to come out with a determination. So if within a period there have been about 2 or 3, so that means that they'll have to be moving in and out of the courtroom that number of times. He was much concerned about time, much concerned about the patience you need to have to wait. What explanation do you have for such a person?
I mean, it's part of the court processes. Not every single time that they have to rise to go consider certain rulings, but obviously it depends on the nature of the application and whether or not it can be immediately dispensed with, and especially where you have a panel made up of more than or about seven people. It's possible that some members of the panel may have different views and will come up with different rulings, and so there will be a need to synthesize all those things to come up with a ruling of the court as a whole. So it really depends on the application in question, but it is not necessarily a rule per se that every single time they have to go rise. But I mean, the dynamics of the case in question or the application in question will determine some of these things. So patience is really a virtue.
All right, no, we have to leave it here, and thank you very much. We'll get back to you. You're going to be with us throughout the entire period, so we'll get back to you when the judges get back to the Supreme Court and with a determination of what is going to happen afterwards. So we'll get back to you. So we've just been talking to Dr. Kwasi Budu. Dr. Kwasi Budu is a lawyer, he's a law lecturer, and the head of Law Center's Gimpa Faculty of Law. He joined us for us to understand exactly what's happening. If you're just joining us, it's the coverage of the 2020 presidential petition, which is being held at the Supreme Court. It's supposed to start at 9:30, which it did start at 9:30. Just when the case started, with the various parties and various stakeholders introducing themselves to the panel, the petitioner's lawyers raised two issues. First, it's got to do with an application to review the ruling of the court yesterday concerning those questions that the NDC wanted to ask the Electoral Commission, of which the judges dismissed those ones. So the NDC wants a review of that particular ruling. The second one has got to do with a motion filed again by the petitioner's lawyers, wanting to have pink sheets and from the constituency, regional and national level, and other electoral documents, some bit of called discoveries. And the judges, hearing these two issues raised by the NDC, the judges said that, well, they'll have to recess and really go back and have a look at the documents, because according to the NDC, they just filed that this morning. That's how come the lawyers were that late in the Supreme Court to introduce themselves. So the judges are currently, as we speak, on recess to determine and look at those issues raised by the NDC. What's going to happen next, we have to wait to know exactly what the judges are going to decide on these issues. Maurice.
Right, so we're still here in studio. We have our men on the ground at the Supreme Court, Abdul Hai Mumen, Edward Nyako and Barbara Kuma, our court correspondent there. They are monitoring proceedings there. Anytime they get any indication or any latest, they will bring you up to speed with that. But just by way of information, these are the justices sitting on the 2020 election petition. Here we have Chief Justice Anin Yeboah. He is the Chief Justice of Ghana. We have Justice Yao Appel. We have Mafo Sao. We have Professor Ashikote. We have Mariama Owusu. We have Justice Nene Amegache and Justice Gertrude Tokono. They are the justices sitting on this particular case. We are told that apart from Justice Anin Yeboah, all the other justices are new ones who didn't partake in the 2012 presidential election petition. And also by way of legal representation for the petitioner, who is NDC's John Dramani Mahama, we have Mr. Tony Lita, and led by Mr. Tsatsu Tsikata. They are leading the charge for the petitioner. We have the EC's lawyer, lawyer Justin Amenuvo. He is leading the charge for the EC, together with lawyer A. Asamoah. They will be doing the work for the Electoral Commission. On the side of the MPP, who is the second respondent, we have lawyer Akoto Ampao and lawyer Frank Davis. We have lawyer Kuku Asrifi and lawyer Yao Opon representing the second respondent, who is His Excellency Nana Addo Dankwa Akufo-Addo. This program is live on GTV, is live on Obonu TV, is live on GBC News and all our regional radio stations across the 16 regions of the country. We're still waiting for the court to return from that short recess to tell us whether they are going to hear the motion filed by the NDC for discoveries. They want to have original coalition pink sheets from the constituency level, from the regional level, and from the national level, even before the case itself resumes. Today actually was purposed for pre-trial and, for that matter, case management. That may have to delay a little bit. We'll see how that goes. No matter what happens, we have correspondents at the court, at the Supreme Court, and we'll bring you up to speed with the latest concerning this particular case. You want to stay with us.
All right, so send us a text message or WhatsApp message. The number is on your screen. Let us know what you think, what you make of the coverage so far. Stay with us. We'll be right back.
Sure. because we are the authentic and trusted voice of Ghana.
One of the best reasons for you to pay your TV license.
Very well. So, GM lawyer Tsatsu Tsikata, no, they have no better particulars. That's why he is playing delay tactics. Abronoma Nyako, Millennium City. I think that's in Kaswa in the central region. The NDC in outside court, you say you have won. NDC in court, you say you want a runoff. Right, that's from a tester from Nungwa. Hi, good morning, sir. I think the judges are trying to protect the image of that's the opinion. Right, this one says, now that the court has ruled against the petitioner's interrogatories, will there be still avenues for the counsel for the petitioner to ask those pertinent questions they seek to ask Madam Jean Mensah? I think that as time goes on,
you know, if you listen to the first respondent yesterday, right, the first respondent's lawyer yesterday, well, he stated that these questions that the petitioner has actually raised are in the petition itself, and they have responded to it. Sure. Of which Mr. Tsikata said that, well, they've agreed. Since he said they've responded to it, that means that there's an agreement that, I mean, these questions are that relevant. So I'm sure when the time gets there, they will raise this.
And also don't forget that they are seeking a review of that ruling yesterday. Yeah. So we wait to see what the court says, whether they are going to uphold that review and allow them to go ahead and ask her those 12 questions. This one says, hi, I'm watching from Glife in Dansoman last stop. It will be very difficult for JM to all right. So this one says, hi, all right. So the COVID-19 is real and no respecter of persons, rich or poor. Wear your nose mask to protect yourself and others, but let Mr. Mahama and the NDC know there is no time to waste on their petition, which is, you describe it as frivolous and vexatious election petition, as described by the second respondent. I think that, I mean, it is very imperative that we wear our nose masks. It's critical. Some 3 days ago, Ghana recorded the new variant of the COVID-19 disease, the virus, at the airport. And so this is a point where we have to take our own destinies into our own hands. Wear your nose masks, wash your hands, sanitize them if you have a sanitizer. The integrity of our judicial system is under serious scrutiny. The judges should remember that one day they won't be there again. So their integrity and the national interest should be protected, not the precedents that will ruin our democracy. Ghana must rise again, you added there. All right, so this one says Ghana will win. Hi, I'm watching from, I think I've read that one already. This one says, good morning. Our judges should know that the destiny of Ghana is in their hands, so they should be careful. Good morning. All right, the same message. Let me read some few more messages. We'll try and see if we can get Abdul Hai Mumen and the team at the Supreme Court, and then they will bring us, what's happening around that particular area. Interesting in Ghana here, election petition, John Mahama should just accept defeat like Nanado in 2013. However, I may say that the NDC are wasting their time. Abubakar Salam, you guys are too much. Keep the good work going. Thank you very much, Abubakar Salam. There. This one says, interesting in Ghana here, election petition should just accept. Okay. All right. Okay, so good afternoon. I am watching live from the Upper East region. Please, I would like to know if 1 + 1 is equal to 2 is correct. Why then should 1 + 1 is equal to 3 affect the results, which is 2? Your message is not too clear there. We're still receiving loads of messages from our viewers.
The interesting thing about the various comments coming in, listen, it's live on television, it's also live on the internet and almost every social media platform. So people actually are watching, and they are forming their own opinion and thoughts as to whatever is happening in there. So I'm not surprised about the various comments coming in from our viewers and also those listening to us too on radio.
Right, and so and let's say these are their opinions.
Yes, these are their opinions.
Not our opinions.
We just have to engage them to let them know exactly what you also make of the entire process.
Sure.
Yeah.
All right. So we are watching keenly. The court must do the right thing by allowing the EC to ask such important questions. Peter from Bacho now. Good morning. My name is Francis Enim. I believe in God and the NDC. Maybe you wanted to add.
All right.
Why can't the NDC wait until question time? Why can't the NDC wait until question time or cross-examination time?
Right.
And they ask the EC all these questions. This from IK Nungwa, and he says that he feels it's some way of delayed tactics from the NDC.
We'll take you over to join Abdul Hai Mumin. We'll be finding out some thoughts from him. He is at the Supreme Court, and we're going to get in touch with him shortly. But I think we're not being fair to those listening to us on radio. The number actually on radio, if you want to send us a text message or WhatsApp message for those listening to us on radio, 055-744-6429. 055-744-6429, 055-744-6429. That's for those listening to us on radio. But if you're watching television, the numbers on your screen, you can get in touch with us and send us what you think and some of your thoughts. We'll read it out. Yes,
right. So George, whilst we wait to connect with Abdul and the team at the Supreme Court, let's read some some more messages. This one says, good morning, I am Samuel Owusu Echampong, currently monitoring proceedings from Doha, Qatar, glued to my TV set. Thank you very much for watching far away from Qatar, Doha. You have to stay glued to GTV because we will bring you the reports as we gather them from the Supreme Court. Good morning. In fact, I like the lawyer for the first respondent, and that's the EC's lawyer.
Yeah.
Is it Justice Amenuvo? Right. So this one says, thanks for reading my message. Thank you very much for reading my message. This one says, the substantive matter for interrogatories was unanimously quashed, but it seems the NDC's joy lies in the mention of Jen Mensah instead of the EC chair. Ghana politics is sweet. Ghana is sweet. Adrianaba from Abeka Republic. Yeah. This one says, delay tactics pioneer from Buedu Emmanuel Ahafo, Mem in the Ahafo region. Hello, you guys are doing a good job. Keep it up. Ghana wins. Certainly, Ghana is going to be the winner after all is said and done. This one says, Ghana shall rise again. My name is Blah. NDC lawyers are indeed good, but they are delaying the process. They are delaying the process.
But that's just like what Dr. Kwasi Anin Yeboah said. And if you read the documents or the procedures that the Supreme Court has actually given out for the hearing of this particular petition, everything is supposed to be heard within 42 days. And that's the expectation. So let's just wait and see exactly what's going to happen on the 42nd day, which will be the final day of this entire process. So let's wait and see. Unlike the 2012-2013 petition that went into 8 months, but this one, there's been a limit to it. So like the 2012-2013, the NDC even joined in that petition, but for this there's been that limit, so it's just the three of them, so nobody else can actually join in the entire process. So and the court has also given 42 days, so let's just wait and see exactly what will be happening within this 42 day.
Right. So hi, my name is Gilbert. I want to ask whether Asiedun Ketia is at the Supreme Court, because he said, okay, right, so I think today Asiedun Ketia he's actually representing
John Dramani Mahama,
the petitioner, who is John Dramani Mahama. Good morning. Good morning. The NDC is winning the case on point. I am Rina Ray GH from Kaswa. That's your opinion. It's the judges that will determine who wins this particular case. But in the end, it is Ghana that wins. The courts may grant the petitioner's request to interrogate the first respondent. I am Frank Mensah in Accra. Hi, good morning. I'm Samuel Boafo, and I want to congratulate you on the good work you are doing I think this petition is not needed because everything shows clear that the MPP is the winner. Thank you very much for acknowledging our effort. This one says, why can't the EC be allowed to answer the questions? Courage is my name. You didn't add where you are testing from. Good morning to you guys. I think the judges are not being fair to the NDC, but God being on our side, the NDC will be victorious. That's your opinion. Tell McMail. Hey. All right, that's fine. Okay, so this one says, hi GBC, talking point. My name is Sydney Abaka from Canada. My interest in the case is to see how Jen Mensa will feel and respond to Tony Lita and Tsikata in the box. That's your interest. We are very much allowed to have interest. Good morning. Michael Owusu from Asokwa. NDC should accept their defeat and the MPP should be happy for their victory. Thank you guys. Okay, so this one says that my name is Papaya, watching from South London, UK. Keep your good work. So we have a viewer, you know, way far in South London watching us. We thank you for staying glued to GTV, for that matter, GBC News or Bonu TV, any of the channels you may be watching at this particular point. Felix from Teshi, the Supreme Court has a big task ahead because it's quite obvious Mr. Tsikata wants to make their work easy, but they themselves want to delay the process. And so, George, I hear we have to go back to the Supreme Court. The judges are back to deliver that ruling on the motion that the NDC filed early this morning.
All right. So let's go to the Supreme Court. I'm sure we'll interact first with Abdul Haim and then we'll move into the chamber itself.
All right. Many thanks to you, Morris, and our colleagues in the studio, George as well. Well, the judges are yet to return to the courtroom after they went into chambers to consider the motion that was applied for by Mr. Tsatsu Tsikata, who is the lead counsel for the petitioner, President John Dramani Mahama, former President John Dramani Mahama. And I'm sure that you are aware that as soon as proceedings began today, the counsel for the petitioner indicated that he wanted a review of the decision that was taken yesterday in respect of the application for interrogatories, which was dismissed by the court. Before then, we had also cited another motion which the petitioners intended to lay before the court today that we haven't heard of yet, but it has to do with asking the chairperson of the EC to make available collation forms, the forms that have become known as the pink sheets, that these pink sheets be made available to the petitioner throughout the process of this case. My colleague Edward Nyakon joins me to bring you an analysis of what has happened so far. So, Edward, we didn't get up to 10 minutes of sitting this morning before the jury went into chambers. For many people, the court even hadn't sat yet. What happened?
Yes, it's because of the motion or the appeal that is being made by the lead counsel of ex-President John Mahama and the President Mr. Tsatsu Tsikata, who is asking the court to look into their own decision that they took yesterday as to the question. They said that it was not relevant to the issue at stake. So he's asking them to look into it again, and it's normal, it's within the purview of his right to do that. So he's come to court to say, look, yes, I agree with the decision you took yesterday, but still I'm not okay with it. Let's look into the matter again. And that's the beauty of law. So that has caused the judges to go retreat and to go and look at the matter, because they need to come out with the various legal backings to buttress the argument they put forward yesterday. So they will certainly go in there to look at it, and perhaps, like I said, the second motion have been filed. Might have also, because Mr. Tsatsu need to also present his argument before that decision will be taken into, that one will also be taken into consideration. So that is what has necessitated the ladder we experience, or the break that we experience now at the moment.
One of the main arguments advanced by Mr. Tsatsu Tsikata counsel for the petitioner yesterday had to do with the fact that there is a precedent, and so he referred to the 2012 election petition which happened in 2013 and actually quoted judgments by Justice Kwasi himself, which sought to support the fact that this had happened already in the past. Some interrogatory applications had been admitted, and therefore, following that precedence, he believed that his application should also be granted. He has a point, doesn't he?
Yes, as for court legal issues, you always have a point, but it's also the judges who sit on the case and have the right to also come out with their verdict. And so if you look at what he said yesterday as part of their ruling, he cited that 2016 there's been some amendment, because 2012, 2013 was a novelty that the path that we took. So it was a move by the court to say that, look here, yes, it was, but remember there's been some changes along the line, and let's not also forget that we have set ourselves a deadline of 42 days to finish this matter. So yes, you quoted some ruling by Justice Kwasi, but we've moved ahead of that. We've also amended ABCD, and that's how we can grant you your request. And so we'll go back to we're saying that, look here, it cannot be granted. Let's tackle the substantive matter, and that's what he proposed, that let's look at the case management and the way forward, which Mr. Tsikata requested. He want to have a look at the ruling, and then he will come back today. And just as Dr. Ayeni said yesterday, they will definitely appeal or go for a review, and they've done that today.
So what this means is that the plans were told about yesterday, just before close of day yesterday, we were told that today would be used for case management, pre-trial arrangements, and so and all of that. This means that might not happen today.
Still, I will say that the judges have the right to decide whether they're going to, because they can come back and say, look here, we've looked through your matter, your review, and this is ABCD. They will come out with their verdict. And secondly, with reference to the second motion you want to apply, he has applied, yes, whether they will allow for argument to be made today, it lies in their bosom, and so they have the right to do that. But once I believe that they have set themselves a deadline, I'm certain that they will go by, because yesterday, let's not forget that the Chief Justice said that they want to be a bit flexible. Though they have a deadline, they want to be flexible. That is how some legal pundits are also saying that perhaps they will not be able to stick to the deadline. But that's the beauty of law. Let's see how it goes, because at the end of the day, it is the judges who have the ultimate power to decide what is within the remit of the law and what is not within the remit of the law.
Many of our followers, viewers, especially on social media, have been sending in their comments. Some seek to suggest that these peripheral issues, so to speak, might end up delaying the entire process. But I also recall that even in 2013, there were several instances where the substantive matter was put aside and other peripheral matters discarded with before we continued with the substantive issues. And so you will recall that in the early stages of the election 2012 petition, there was the amicus curiae, Benoni Amekuji, who came in to as a friend of the court to make some applications. His applications were heard, but later dismissed. Of course, we also do know about the several cases of contempt that were heard during the 2012 election petition. And so this is not new at all, that certain matters other than the substantive matters have to be dealt with by the court. Edward.
Exactly, because if you're a lawyer pursuing a case, I think that you know what you want to achieve. So you have your game plan. So it's just like a coach. So you have a plan A, plan B. So Who knows? This might be part of the game plans to get exactly what they are looking out for. So like Mr. Tsatsu Tsikata said yesterday, this is aimed at narrowing down the issues and to elicit some response from the EC. So these are some of the things they put out there to get the specifics they are looking for. Nobody knows what is in his mind. He knows what he's looking out for. And therefore, we don't have to discount on these things. It is part of the legal issues that need to be brought up. And so it's up to the opponent also to raise issues, because at the end of the day, you need to quote specific laws to buttress your argument. And that's exactly what is happening. And I always say that, look here, that is what democracy is about. I say what I want to say based on the law, and then we chart a new course. And on her side, we realize that the judges that are sitting on this case might have experience, not all of them sat on the case, but they might have a look at what transpired in 2012. So yes, we countenance what happened in 2012, but perhaps this time around we've got some experience under our sleeves. We're not going to consider all these peripherals, like using your word, and so we're going to go forward and deal with a substantive matter. But like the Chief Justice said yesterday, they want to be flexible and then let the case pursue. That's how you threw it to the various the petitioner and the two respondents. They should come together and agree on when to start the case management, and there wasn't a consensus.
Again, let's talk about what happened in court, albeit very briefly. We realized that on day one, former President John Dramani Mahama himself was in court. On day two, which was yesterday, he was in court himself. Today, we haven't seen him physically. We've seen Madam Jane Mensah together with her deputies in court today. Okay, so now we are getting signals that the judges are returning to the courtroom. We will continue to bring you details. Edward, you would have to move in there. Thank you very much. We'll hand you back over to the courtroom. The analysis will continue from here. We'll bring you all the details. Stay with us here on GBC platforms.
Anyway, we are sorry too. All right. By court, we have considered the petition and the answers to say by the respondents and the memoranda of issues set down by the parties. We accordingly set down the following issues for the determination of this petition. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of their valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techi-Mansard constituency presidential election results. 4. Whether or not the declaration by the first respondent dated the 9th of December 2020 of the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1992 Constitution. 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. By virtue of the powers vested in this court under Rule 5, Sub Rule 4 of CI 99 to dispose of this petition within strict timelines. The following orders are made accordingly. 1. Mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2. The witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3. The respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4. The first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021. 4b. The registrar shall ensure service of the submissions of the preliminary objections by the close of the day on Friday, the 22nd of January 2021. C. The petitioner shall file any response to the submission of the preliminary objection by noon on Monday, the 25th of January 2021. D. The registrar shall ensure service of the petitioner's response by the close of the day on Monday, the 25th of January 2021. E. Ruling on the preliminary objection will be incorporated in the judgment of the court. Timelines. The court shall sit on Tuesday, the 26th of January 2021 for hearing of this petition.
My lords, we have just heard the orders that you have made. We thought that part of the hearing this morning was in effect to enable us to make representations on the various things, but it looks like your lordships have made certain orders, and there is some degree of unclarity, at least in our minds, as regards what is referred to as a preliminary objection. Because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
Of the primary objection. The issue to be determined as preliminary objection. That has been set out as read by the President of the court.
Well, perhaps we could hear it again, because it was not...
Is whether or not the petition discloses any reasonable cause of action. That's it. Please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. Because it's case management, you have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements. Is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning. As of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other party. There are a number of outstanding issues which have not been discussed.
Mr. Tsikata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99. And to have the notice to admit.
Yes, but my lord, it can affect the issues. In fact, your lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Tsikata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements, yes, which are limited to.
You are already call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses, but in any case, we have now, today, until tomorrow, in order to prepare witness statements.
Mr. Tsikata, this should have been prepared already. No. Well, these statements should have been prepared already.
Well, that is not correct. maybe your lordships,
Mr. Tsikata, excuse me. Mr. Yene, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Tsikata whether they were limiting themselves to the only 2 counsel. Mr. Tsikata, I think you remember the very day, and you said you were with only Mr. Luther, and you were recorded as such. But Mr. Yine, please, out of respect for you, please don't do that again.
Mr. Tsikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Tsikata, you know about CI 99 and its schedule. That's the 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
We are grateful to the court. Please, resume your seat, please.
Lord, we are most grateful.
happens Thursday himself.
All right. Let's go.
Counsel, your reaction to the ruling of the court.
Out.
Came out of court. You all know what was scheduled for today was to be the pre-trial hearing. But before that, the petitioner's team, lawyers, had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of the interrogatories. Well, the court took cognizance of that and retired into chambers to consider the issues that we had been ordered to all file. So at the end of the day, the court came back and read the memoranda of issues. 5 issues have been set down for the trial and determination of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing of the petition in strict conformity with the CI 99. So we are all supposed to be back on the 26th of January, that is Tuesday, this coming Tuesday, for the hearing of the petition to commence in earnest. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable cause of action. Indeed, in second respondent's answer, that matter was raised by the second respondent's legal team as a matter which should be considered by the Supreme Court, and that has been set down for preliminary legal argument. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you. They were advocating for a live broadcast of the proceedings. Not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint or the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric of sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
As an interested party, are you not concerned that in the future, when this case has traveled and the issues are brought back, that it could take all of us back to the very beginning of matters?
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
Please. It's okay. It's not working. It's okay.
Yeah,
yes, what is are we going to ask?
No, I think we just
okay.
And greet them and then.
All right. Good morning.
All right, Counsel, thank you very much. Give us your reaction to the court's ruling today.
Well, we are quite shocked because we are here for pre-trial, for case management, and for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you will come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel, for the second respondents think that they're not well prepared for this trial. You seem to raise objection to everything the court raises.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by Lead Counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as he stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something that you will be able to meet? And in terms of your case, you are the ones who have got the case to court. And what does it mean for putting together a solid case to put across your points?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court. We wouldn't have filed the petition in the first place. All we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 26th to commence a trial, how are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of the 2013 petition,
yes,
and the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial. What do you make of it?
Well, we are yet to, I mean,
Serve the order.
we are yet to be served the order. We are now going to look at, because it was just read to us. We need to now sit down and look at it. Did it, because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed, and the court bringing it together so that we are all agreed on the issues. That didn't happen, so we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Your colleague, Dr. Ayemi, was demanded by the court for certain gestures. What response to that?
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Can we get tea version?
Yes. Baba Jamal.
Yes.
Yeah. This one, you are dealing with your friend.
Yes.
Your friend.
The chief can come up.
Mr. Ene, once my boss I have a specific question. Which one?
What has accounted for the inability of the plaintiff?
No, it is not the inability of the petitioner to bring witnesses. All right, we had indicated, in our petition that we will be calling most likely 5 witnesses.
Yeah.
Okay. Now we thought that at case management, at the time of case management, which is 5 days of, a 5-day timeline granted by the court itself in the new rules. Okay, we thought that we should be in a position, to plan together with the other parties on how many witnesses we are going to call. So it was not the case that we are not prepared with our witnesses. It is just the case that we are met with a situation where we are being given 1 day to prepare our witnesses and then make sure that we file the witness statements, by noon of tomorrow. So it is not about, it is about tight that are being given by, and I think that the court is being very unfortunate. When you have indicated that pursuant to CI 99, there are 5 days for case management, and all of a sudden the case management is reduced to 1 day by the court arbitrarily without any consultation with the parties, all right, then that is like our lead counsel, Tsatsu Tsikata, made it very clear. They are seeking to sacrifice justice on the altar of a so-called speedy trial. Okay, and that is not fair. The fact that we spent 8 months, right, dealing with the first presidential petition does not mean that now everything we do must be geared towards, attaining a speedy trial at the expense of fairness. Okay, and I think that is a very worrying development.
But your opponents also say that justice delayed is justice denied. Speed and justice probably go together in this instance, and the assertion is that you are delaying.
No, that means that you cannot sacrifice one for the other. Justice delayed is justice denied. That is true. However, the court itself has indicated that we have 42 days to complete this trial. It means that in the wisdom of the drafters of the rules, that is the Rules of Court Committee, 42 days are sufficient for purposes of conducting a trial in relation to a presidential election petition. Okay, you cannot now begin to truncate and deny the parties the right
to be able to, for instance, file preliminary, applications that are mandated and allowed by law just because you want a speedy trial. Okay, and I mean, to be honest with you, I was shocked at what was happening, and you all realize that the Chief Justice singled me out, that my body language was inappropriate. But that is because I was very shocked, because after 25 years of law practice, I have never seen this happen, that a court will arbitrarily announce the timelines for the parties without consultation. I had occasion to ask Mr. Akoto Ampao why he did not object to the tight deadlines. Okay? And sitting down there, it reminded me of an inscription that was on the desk of my secondary school rector in Notre Dame Secondary School. It said, "Don't confuse me with the facts. My mind is made up." Thank you very much, ladies and gentlemen.
Thank you very much. Honorable Kojo Ponkroma, who is the President's representative at the Information Ministry, will speak to us now. Yes, so how do you react to everything that has happened in court today, very briefly, sir?
I think all of us need to go back to the basics. Ordinarily, when you file your petition and the respondents file their answer, the next logical step is case management, which starts with a setting out of the issues and then a timetable which includes when witness statements are filed. On the first day when we came, our colleagues from the other side started off with an interlocutory application asking for leave to go and amend. And therefore, they started delaying the 42-day clock. That was granted. We had the opportunity to come back earlier this week, and the afternoon before we appeared in court, they filed another interlocutory application, which, as you all saw, took us, almost 2 hours or so, and the court dismissed and said, let's go back to case management, which is what we should be doing now. Every lawyer knows that by now, when you are coming to court for case management, first, your memorandum of issues, you've drafted it. Second, your witness statement, you have a draft of it. So these matters become procedural. Because our colleagues are seeking to delay the process and get a media spectacle ongoing for some months, all they are doing is theatrics in chamber, seeking to delay the time. So today, even after the court has ruled, or just before the court rules, they bring another application for review. Every lawyer knows that the law is that an application for review or an appeal does not operate as a stay of proceedings. Every lawyer knows this. So you cannot claim or pretend before the cameras that by mere virtue of the fact that you have filed an application for review, there ought to be a stay of proceedings. Because it has actually been, I think, slated for hearing tomorrow. The return date, I think, is tomorrow on it. It will be heard.
Counsel for the petitioners feel that they in fact took an exception to the argument that they are delaying the trial.
They are allowed to take an exception.
What they are doing is due process.
They are allowed to take an exception. But I want to come to another issue. When the court determined in the end that witness statements should be filed on X or Y date, you can check from any other lawyer. Mr. Mahama filed his petition on the 30th of December. True or false? Okay. Nobody chose witnesses for him. He listed 5 people that he had as witnesses. That presupposes that he knows who they are. He knows what they are going to say as witnesses on his behalf. Today, when the court says that by this date, bring me the witness statement, now they say it's too short and that they are being rushed into putting together witness statements. We didn't choose their witnesses for them. From 30th of December till now is what, 20 or 21 days? And Mr. Mahama's lawyers are saying to us that they have not drafted witness statements. They don't have a draft of it. From 30th of December, when they filed their petition and chose their own 5 witnesses, they didn't know what the witnesses were going to say. They haven't drafted it. Respondents have listed what they want to do, and we have a fair idea what it takes to contend this case. Now, if they claim that they need to go back to the interrogatories before they can agree to the issues as have been set out and prepare their witness statements, what it means is that they are application for interrogatories were a fishing expedition. That what they were doing was to use it to explore what issues they can come to court with. They have been very clear to the Ghanaian public that Mr. Mahama won this election. Mr. Mahama himself at his press conference said he won the presidential election. That means what? He got 50% plus 1. You have an opportunity in court to prove that. Now Mr. Mahama abandons that one and moves on to this new thing of nobody got 50%. And when we say bring your witness statements, he says it's too early to bring his witness statements. Okay. That's ridiculous. And we are of the view that these are just efforts to delay what CI 99 sets out clearly, that there must be justice, but it must be done expeditiously. Nobody is short-circuiting the process.
You seem to emphasize the fact that your opponents are seeking to delay the process. Because what do they stand to benefit if they delay the process?
For a media spectacle so that Mr. Mahama can continue to remain very relevant in the NDC and in the public space and run again in 2024. That's all they are looking for.
So he stated that in terms of case management, it should be done among the parties involved in the case. But this time, the court has set its own rule, and they find it very ridiculous.
That is not true. You were all in court yesterday. In fact, even yesterday, when the court said that they should make their input into the first part of case management, which was the memorandum of issues, you saw them object. The court could have set, in fact, traditionally, the court will set out the issues. Now with the reviews, CI 87, etc., with the reviews, the court will invite counsel that give us your memorandum of issues and let us come up with a timetable. Let's listen to your issues and simplify. We went with 3 issues. And then the court came up with about 5 issues. 2 other issues that we were not contemplating. The court has added it as the list of issues. We are not complaining. We think we can respond to
right. Honorable,
this claim. You were all in court yesterday when they were even asked to file their memorandum of issues. You noticed that this morning they were late in the chamber. They were late in the chamber because they claimed they were now filing their memorandum of issues after they submitted their petition on the 30th of December. Now they are being asked to bring their witness statements. They are suggesting that it's too early. 21 days after they told the whole world that these are our witnesses, they have evidence to support our petition. And that is why we are saying that they are continuously trying to put impediments in the way because they want a media spectacle. To keep
Honorable, for the millions of Ghanaians, lay persons watching us right now, who perhaps also sympathize with your side and who do not understand what the court ruling was today, how would you summarize it to them?
The court has ruled today that let us get on with the issues. Let the petitioner prove that nobody got 50% plus 1. Let the petitioner prove that the results were in contravention of Article 63 of the Constitution, as he's been claiming. I would have even preferred that they had come back to say that Mr. Mahama won this election. But you notice that they have abandoned that since they came to court. And so the court did not pick that as an issue. But what the court has said is that all the gymnastics around, let's get to the substantive issue, and has asked us to come and deal with the issues that it has set. In Chi,
all right, thank you very much. And that was the Minister for Information, Mr. Kojo Ponkroma, speaking to us earlier. We also spoke with the Minister, the former Deputy Minister and Attorney General, Dr. Dominic Ayine, and both of them telling us their points of view as to what happened in court today. The Minister for, the President's representative at the Ministry of Information making a claim, a very strong claim, and I'll be joined by my colleague Edward Nyakon, Barbara, who also joined me at the moment. So as we begin to wrap up for the day's events, Barbara, let me start with you. The Minister says, well, now the court has given, paved the way for the proceedings to hear the substantive matter to begin. What was your understanding of whatever happened in court today?
Well, I think I'm going to agree with the Minister when he said that. I mean, the court says that now let's stop with all the gymnastics around. Let's get into the real matter. Let the petitioner come and prove his case. Come and prove to the court if he indeed has any case to be argued about, or to even for the court to listen to. So yes, I think it's about time we started the trial itself, and the court has said it, that next week, Tuesday, 26, we sit on the petition itself.
Edward, but again, notice. I mean, proceedings came to a halt for the jury to take a break and go into chambers to take a decision. But that was because the lawyers for the petitioner had asked for a review of the decision that was taken yesterday, dismissing their interrogatory application. Again, when the court came back, one of the issues they spoke to was the fact that, well, the fact that the petitioner has asked for a review does not place a stay on the proceedings, and therefore the proceedings will continue. But then again, the question is, at what point will a decision be taken on the review? And if a decision is taken and it goes to the advantage of the petitioners, will that not then put everything in reverse gear, since we would have moved forward at a point?
Well, if you listen to the arguments put forward by both sides of the coin, that is the second respondent legal team, as well as the petitioner's legal team, you realize that if you look at it from the view of the second respondent, they are claiming that it does not affect the substantive matter because the judges are masters of their rule. And so if they are set tomorrow for that, and they are expected to also to file their memorandum of issues and witness statement today by close of day, it doesn't change the matter at stake. And so they are in the position to deal with it. And but if you look at it from the angle of the petitioners, they are also saying that, look, it will affect the statement of the memorandum of issues and witness statement they will put out there. So these are all legal issues, but let's not also forget that the court indicated that they have looked at, they should all be mindful of CR 99, which set the rules that, look here, we're not going to go the way we went 2018. We have to set a rule, and there has been a review, an amendment to all those previous issues. So pre-trial matters should not be able to stay or prevent this substantive matter from coming on board. So this is how the issues are playing out.
I'll come back to you, Edward, but the issue, and let's toss this around amongst us. You know, the lead counsel for the petitioner says it appears as though the court is sacrificing justice for expedition, justice for speed. Does he have a point? I mean, from the arguments he made and so on. You have been reporting from court for a long time. Is there a way that justice goes with speed at the same time?
Yes, definitely. I mean, it is not every time that you come to court and the processes are delayed here and then and all that. I believe the Supreme Court and the justices of the Supreme Court are well aware of the laws, and they know exactly what they are doing by asking that we fast track the process. At the end of the day, justice will be done to whoever deserves justice. And so, well, the petitioner, they have their own issue, but I believe that the law is working, and that is what we should allow, or we should allow to go through the whole.
All right, Edward, your take on that as well?
Yes, it goes back to the CR99 that judges refer to, that Mr. Tsikata should refer to the CR99, which he agreed that he's aware of that, the schedule that indicate that it must be dealt with within 42 days. So in the purview of the judges, this is the way to go. And as always said, they are the masters of their own game because they set the rule and they can do whatever they want to do with the law.
We have to go now, but very finally, so court sets again exactly when? Because we heard announcements about filings being done on Thursday and on Friday. Yet we
substantive matter, court sets on Tuesday, but on the review, it will be done tomorrow.
So tomorrow we are coming back to court?
Not for the substantive matter, but for the review. But for the filing of the witness statements and other processes, it should be done within by the close of this week. That is what the court has ordered.
All right. Thank you very much, Barbara Kuma, and thank you also, Edward Nyakon, my two colleagues who have been here with me in court. Earlier, we also spoke to our other colleague, Beatrice. Yvonne, our other colleague from the radio, has also been here. We will continue to bring you all the details about Election Petition 2020 and whatever you need to know, including what will happen tomorrow. This is where to get all the authentic information. My name is Abdulhai Mumin. We are grateful that you have been doing this with us. We'll go back to our studio where our colleagues are standing by to bring you further analysis of all that has happened in court today. That they were seeking. The court returns to spell out the modalities of the case, how the case is going to be handled, and they have given 5 orders. One of them is whether the petition discloses, if any, reasonable course of action. We have our lawyer on via Zoom. We'll be speaking to him to understand some of these orders. Whether or not no candidate obtained more than 50% of the votes, valid votes cast. Whether or not the second respondent, who is Nana Addo Dankwa Akufo-Addo, did not violate Article 63.3, which says that a winning candidate must have 50% plus 1 of the valid votes cast. Whether or not the declaration violated Article 63.3 of the Constitution. So those are some of the orders and how the whole process is going to be handled in court. We still have on the line lawyer Dr. Kweku Ajiman-Budu. He is a law lecturer and head of law centers at Gimpa Faculty of Law. Good afternoon to you, Counsel. Welcome back once again. Right, and so briefly, can you help us understand what's transpired after the court returned from that short break?
So basically, it's just as you mentioned, and your colleagues on the premises of the court pointed out. First and foremost, the court has set down the issues for trial, as you rightly pointed out, 5 issues. And we were talking about it earlier on when I suggested that it will, the whole idea or part of the reason why you have case management or pre-trial is usually for the parties to assist the court in setting down the triable issues or the issues that will be determined or the determination of which will resolve the matter or dispute at hand. So we noticed, or we pointed out that the parties had filed their memorandum of issues. We noted the fact that the second respondent in particular, we had seen copies of their memorandum of issues in which they set out 3 issues. But at the end of the day, the court in its own wisdom decided to come out with 5 issues, some of which you've mentioned. And if I could quickly go through them. The first issue was whether or not the petition discloses any reasonable course of action. Reasonable course of action being whether the petition is actually in line with Article 64(1) of the 1992 Constitution, where you have the right to challenge the validity of the election of the president. The second issue is whether or not, based on the data which we have, whether no candidate got the more than 50% required under the Constitution of Ghana, Article 63.3. Then the third issue is whether the second respondent met the threshold of the more than 50% of the total valid votes cast. Note that it didn't say 50% plus 1. It says more than 50% of the total valid votes cast. That's what the Constitution actually prescribes. So whether or not the second respondent met that threshold by the exclusion or the inclusion of the Techiman South vote. And we know that The total number of registered voters in Techiman South is about 128,018 or so. Then the fourth issue that the court set out was whether the declaration made by the Electoral Commission was in violation of the Constitution, and finally, whether the alleged vote pattern and errors affected the overall result. So that's the first thing that the court essentially did, setting out the issues that are to be resolved for the purposes of disposing of this particular matter. Then the second thing that the court did was to give some orders in terms of how the trial is going to be conducted, or the hearing is going to be conducted. So they talked about witness statements being filed by tomorrow, service of these on counsel, responses to come the next day, and so on and so forth. So in a nutshell, and then hearing will begin on the substantive matters on Tuesday, 26th January.
Right.
So in a nutshell, that's what we saw happen.
So we didn't see the petitioners file their memorandum of issues. I may be wrong, but I didn't see the petitioners file their memorandum of issues. In fact,
you don't have to see it as long as it is filed in court and it's brought to the notice of the Supreme Court. It's good enough. The fact that we're seeing some of these things being published on social media doesn't necessarily mean that they haven't been filed. So as the petitioners and representatives of the petitioners themselves said, they filed their memorandum of issues earlier this morning. And so I'm pretty certain that all parties in this case have filed their memorandum of issues in line with the orders that the Supreme Court made yesterday, or the instructions or directions that the Supreme Court gave yesterday.
All right, Doc, let's come to case management. How is case management conducted in court?
I mean, we've talked about this earlier on, and many of the people who've spoken have set it out. Like we said, usually it is during this process, and we've seen it play out before our eyes. It's during this process where, for instance, the issues for determination are set out. So, for instance, the court can ask the parties to the dispute to assist the court in determining the issues that should be determined in the resolution of the matter at hand. And so that's why memorandum of issues are filed, or parties can file memorandum of issues on the basis of which the court may determine the issues which they feel is relevant in the disposition or in dealing with the matter at hand. And we've seen that happen in this particular instance. So that's something that happens during this process. The mode of trial and how the hearing will be conducted is some of the things that happen generally as well, depending on the type of case that you're dealing with. And so I believe we've seen this exhibited in this morning's sitting.
All right. Now, from yesterday, the judges had said that today was going to be for case management. And from your explanation, it's got to do with both parties, or parties assisting the courts and arriving on issues that they would like to be addressed during the trial. In assisting the court, is it usually done by writing, or is usually orally to understand that the perspective of both sides coming in, based on what has happened today? Because we did not actually clearly see the understanding there. Was it based on what was written, or what?
Oh no, the direction of the Supreme Court was clear yesterday. They directed all parties involved to file their memorandum of issues by 9:30 a.m. or 9 a.m. this morning. So it was pretty clear, and I'm quite certain that all parties in this dispute did as directed by the court. The fact that we have not seen it doesn't mean that it hasn't been done. So that's something that we need to make.
I'm talking about parties agreeing to the issues. We didn't actually see that. Well, these parties agree to the 5 issues.
Ultimately, it's up to the courts to determine. Remember, it's the court that is supposed to dispense with justice. And like I said earlier on, or dispense justice, actually. Like I said earlier on, the fact that a party has listed or has filed, say, 3 or 4 issues doesn't mean that all those 3 or 4 issues will be adopted by the court. Because at the end of the day, on the basis of the issues that have been filed or the issues that can be deduced from the petition itself, the court in its own wisdom, with the assistance of the parties, by virtue of the memorandum of issues that have been filed or presumably have been filed, will then make that determination that on the basis of all these things and on the basis of the petition as a whole, these 4, 5, 6 issues we believe are the issues that if we are able to resolve, will resolve the petition as a whole, and we will be able to do justice in this particular manner. And I believe that is what has transpired in the Supreme Court this morning.
Right. So this morning when the court sat, the NDC or the petitioners filed a motion to review the ruling the court made yesterday. But we didn't see the court make any specific statement or reference to that particular review. What happens to it? Is it going to be determined in the course of the case?
Yes, like one of the justices pointed out, that filing that application for a review of a ruling of the court does not necessarily operate as a stay of proceedings. And so proceedings can still go on whilst the matter is dealt with. So I believe the Supreme Court has been clear in that regard. So we wait and see.
And still on the case management, you got to know that CI 99 talks about 5 days for the case management. Does it also mean that the court in its own wisdom can decide to do that within less than the 5 days given?
Clearly that's what has happened, and so like I said, the court determines how it's going to deal with the petition. And as we've noted earlier on, and as it's clear from the CI 99, the Supreme Court rules as amended, there are strict timelines within which the petition must be disposed of. And telling from what happened in court today, we can tell clearly that the court is bound, or the court is determined to strictly adhere to the timelines as provided for in the law. So I guess that answers the question that you're asking, that things will proceed from where it's where we left today, that the court has made that order that on Tuesday 26th January hearing actually begins. Yes.
Right. So let's talk about the petitioners or the witness statement in handling a case. At which point do you prepare your witness statement? Because it looks like the petitioner says they don't have much time based on the orders that the court has given. But the second respondent's lawyers also feel that the witness statement should have been prepared long ago. You are a lawyer. At which point of a case do you prepare your witness statement?
I mean, it depends on the nature of the case and what specific rules are in place for that particular type of case. But for instance, in this election petition, we know clearly that there are strict timelines within which the matter is supposed to be disposed of. And so, as the Supreme Court has made or has instructed the parties to this dispute to file their witness statement by the 21st of January, which is tomorrow, I believe that will be complied with, regardless of whatever qualms anybody has with this particular order of the Supreme Court. So that's what we have to abide by, or that's what we have to look towards and see if that is complied with. But I believe it should be complied with, because that's what the Supreme Court has ordered.
All right. Now, Doc, hypothetically, if what's going to happen tomorrow, hearing of the applications filed by the NDC, the reviewing of yesterday's judgment, and the motion seeking to get certain documents from the Electoral Commission, hypothetically, if it goes to the NDC's favor, what happens to the various documents they're supposed to file, especially the witness statements and all that they're supposed to do tomorrow?
You know, I can't speculate on these.
I mean, hypothetically though, I mean, what's really going, is that going to affect all those things?
Yeah, it's hypothetical, but it's still veering into the realms of speculation. I mean, the court has. I actually didn't hear at any point in time where it was suggested that tomorrow is the day that there will be a decision on that particular application that was made, requesting a review of the court's ruling on the interrogatories yesterday. Maybe I missed something, but I actually didn't hear that part. And so if that is the case, then we would have to wait and see what happens there, because the court has clearly come out with the mode of trial, and the court clearly stated through one of the justices that the fact that an application in that nature for a review has been made does not necessarily mean that all proceedings should come to a halt or a standstill. And that
but it also means that those applications will be heard, right?
Yes, definitely it will be heard. Yes, that's what they said. And if you notice, the court, even in giving the orders, talked about the fact that the preliminary legal objections that were raised by both the first and second respondents will be a determination of those will be included in the final judgment. So that's something that you need to note as well, because ordinarily, if you raise a preliminary legal objection that goes to the core of the matter and it is upheld, that brings proceedings to an end. But the court, in its own wisdom, has suggested or has instructed or told us that that will be dealt with in the final decision or judgment that it will deliver when it so delivers.
Right. So we know that this particular case is governed by CI 99. Which has given a specific timeline for hearing the petition. Why has it become necessary that we do this quickly? Also bearing in mind, as somebody said, that we don't sacrifice justice on the altar of expedition.
I think in the wisdom of the Rules of Court Committee, they believe that, and we need to point out the fact that, yes, we have the saying that justice delayed is justice denied. And yes, there's this other argument which you're pointing out, that you shouldn't sacrifice justice on the altar of expediency. But the point is that the rules are the rules. And we saw how drawn out the 2012-2013 election petition was, which took over 8 months with all its uncertainty, because of the fact that Article 64 of the 1992 Constitution gives the Supreme Court the power to invalidate the election of a president. Yeah. And so I believe that having all these and having the experience of that particular election petition, it was decided that as a matter of fact, you can deal expeditiously with an election petition of this nature within a strict timeline, a relatively shorter period of time, and still serve justice. So I believe, in my opinion, I may be wrong, but I believe that that may have been...
Hello, Doc. Oh, usually technology is not really a good friend at times like this. We try as much as possible to re-establish contact with Dr. Kwaku Anin, who is a lawyer. He's also a law lecturer and also the head of Law Center's Gimpa Faculty of Law, trying to get some bit of understanding as to what happened in court today. To bring you up to speed, the court has determined 5 issues that will go for trial on the 26th of this month, 2021, which is coming Tuesday. The court has also given out the mode of trial for what is actually expected, and told the various sides to file their witness statements within the coming days, and other statements and documents also needed within the coming days. Of course, the petitioner has also raised a couple of issues during the presentation of the judges, of which the court said that yes, you brought an application and a motion, but that doesn't mean that it should put the main case on hold, meaning that these applications also will be heard, and subsequent issues that also followed. The interesting bit has got to do with the case management aspect of it. The petitioners, which is the NDC, saying that, well, they were expecting that to be done within 5 days. but the court went ahead to give everything that it needs to do within this particular time, giving 5 issues out. An interesting quote coming from Tsatsu Tsikata, who is the lawyer for the petitioners, saying that we don't have to sacrifice justice for expedition. And of course, Frank Davis, who is also the lawyer for the first respondent, part of the legal team for the first respondent, also said that justice delayed is justice denied.
All right, so it's going to be a combination of the two, you know, quotes. How do we put all that together? Trying to ensure justice and also trying to ensure that we do this in real time. Because for the sake of the economy and for the sake of governance, we don't want to be in court for 8 months.
Right.
I mean, being in court for 8 months, I mean, during the 2013 hearing really affected the Ghanaian economy. There was the lack of confidence. Investors had taken the let's wait and see approach, and that affects, you know, a lot of things. So I think that it's going to be a blend of trying to ensure justice at the same time doing it quickly and in real time.
Maurice, I find it difficult to understand the delay aspect, because the court itself said 42 days.
Okay.
The thinking is that the court will consider everything that happens in court proceedings and in trials. The court will put into consideration whatever processes that actually will amount when a trial like this is going on. So at the end of the day, the final conclusion is 42 days. If that happened, and if that is what has happened, which I believe that should be what has happened, why should delay be an option here? Why should people be talking? Because I find it difficult to understand the delay aspect. Because the court will put all these things into consideration, and these are processes that they go through in courts. Right. They said, okay, we'll do this within 42 days.
Right. So I think that, as I said, the law is in the bosom of the justices. So they know what we don't know. So what you may see as not delay is delay in their sight. And also don't forget that this particular petition, as I said, is governed by CR 99.
Exactly.
And as lawyer said yesterday, it even doesn't allow for reviews. But the Chief Justice has said that they are going to be accommodating as much as possible. So anything they are doing is in the frame of the law. So delay will be determined by the justices.
All right, we have Doc back on Zoom. Doc, we lost you there on the line. You were explaining certain issues to us. If you can continue on that. Hello, Doc.
Can you hear me?
Yes, we can hear you now. Yes.
I was asking if you could remind me where we got cut off.
We're talking about the bit about justice and its time frame. The aspect of sacrificing justice for expedition, the aspect of justice delayed is justice denied, and the time frame given by the court itself. So in all this, it's a fight between justice and time.
And speed.
I mean, so I was saying that they weren't necessarily incompatible, and that in the wisdom of the Rules of Court Committee, they decided to make amendments to the Supreme Court rules specifically dealing with the disposition of election petitions, and they felt, or they must have felt, that the 42-day time period was enough for such matters to be dispensed with. So I do not necessarily believe that, and we know what happened in 2012, 2013, where we had a long drawn-out battle in the courts, which had an effect one way or the other on the economy and on our lives. We remember the tension surrounding even the day on which the Supreme Court was to make their final determination or give their judgment on the matter. We saw what was happening in town, the palpable tension that you could feel in the air and all that. So I believe as part of it, and I mean, even for the person who has been prima facie validly elected as the President of the Republic of Ghana, for peace of mind to even continue governing and going about the government business, you need such matters settled as quickly as possible. That is not to say that you will sort of do away with justice. Justice still can be done within that time frame, and I believe that is what the court is going to ensure is done.
Right. So I know you've told us that you would not like to discuss individuals, but there was something that happened in court today. Lawyer Dominic Ayine, one of the justices didn't like his body language.
The Chief Justice.
Okay, the Chief Justice. So just so all of us are aware, so that when we go to court, we know how to sit and how to compose ourselves. What does body language in a courtroom mean? What does it say?
You just answered your own question. Just comport yourself.
Well, comport yourself means what?
It means everything that goes into comporting yourself when you are in a place of decorum, when you are in a place and certain things are required of you. For instance, you don't go to, for example, a courtroom and go and turn on your phone and be listening to radio or be picking a phone call and things of that sort. So there are a lot of things. Comportment means exactly what it is. You're supposed to behave in a particular manner. And I believe that we all know the proper way to comport ourselves and improper ways of comporting ourselves as well.
Let me find out this. Is body language not subjective?
Meaning what?
Meaning the understanding of what you understand someone's body language might be different from what the person's own understanding of his body language is.
I mean, it's possible, but there are certain things that, and now we're speaking generally just to make it clear.
Yes.
I'm no expert on body language, and so I can't purport to understand or appreciate people, the subjective views of how body language may be. But there are certain things that if you do, or certain gestures, which generally speaking have one meaning. And I mean, there are some gestures that are not appropriate. If the person engages in such gestures, you would know, you would have a sense of what the person is feeling or is trying to suggest with his or her body language. For instance, if someone is talking to you, and once again, I'm no expert, but if you roll your eyes at someone, I mean, what does rolling your eyes mean? But I think just to make things clear, it's subjective as you said, but I mean it depends on the circumstances and the situation as well. And I'm no expert, and so I can't purport to even delve into such matters.
All right. So on the 26th, that the court is going to sit, what should we expect? Are we expecting the trial itself to begin on 26th?
Yes, that's the understanding from the orders that were given by the court. They set out clearly the mode of trial, and they pegged Tuesday, 26th January as the day that hearing will actually begin. So we expect that hearing will begin on 26th January. And the fact that they have instructed the petitioner in particular to file their witness statements, or witness statements should be filed by the parties on 21st January, that's tomorrow, suggests that by the 26th, when the hearing begins, we may have a sense of what's going to happen. We may have a sense of the court trying to delve into the substantive matters that would lead it to the resolution of the issues that they have set out. So what we can deduce from what the court did today is that it did two things. The first and foremost, set out the issues that it will have to determine for the purposes of resolving the case. Then it talked about the mode of trial and the administrative stuff, if I may put it that way, that needs to be done for the resolution of the dispute. And it is those things, the witness statements and subsequent processes that will emanate thereof, that will lead to the determination of the issues, whether or not the petition disclosed a reasonable course of action, whether anyone got the more than 50% as prescribed of the total valid votes cast as prescribed by the Constitution, and so on and so forth. So that's what we expect probably to see on 26th, but we wait to see.
Right, so we're going to court tomorrow.
I don't know that. Like I said, I did not particularly, and I may be wrong, but I did not hear the court suggest that we'll be coming tomorrow. But let's wait and see. Maybe I didn't catch that part, but I didn't particularly. All that I heard was that it wasn't the application for the review of the ruling on the interrogatories didn't operate as a stay of proceedings, and that matters will continue. So if it's been set for tomorrow, I don't know about that, but maybe if we have more information from the court, that will clarify those issues.
All right, thank you very much. Two quick issues. The first one is, just for us to understand, it means that the 5 issues listed by the justices, they are going to rule based on these 5 issues, right?
Yes, that's what generally it means. Once they've set out those 5 issues, the court, once the hearing is conducted, in delivering its judgment, it's most likely going to answer these 5 issues so as to be able to make a determination on the petition as a whole.
Okay, and my final issue, which is usually what I call just on the side, you as a lawyer and a law lecturer, watching these entire proceedings at home, what goes through your mind?
The law at work and the essence of democracy, where people have rights enshrined in the Constitution, where no one is above the law, where even if you've been prima facie validly elected as a president, the validity of your election can be challenged, where institutions are held to account. The Electoral Commission, for instance, is an independent constitutional body, but they've been brought to court and essentially made to justify the decisions that they took and the results that emanated from the conduct of the election. So it is part and parcel of our constitutional process, and I believe that it helps build our constitutional jurisprudence and the development of the country generally.
Would you wish I push you a bit further, or we should leave it here?
You can,
okay.
As long as it.
All right. Let me. Since you've agreed that, I'll push you further. I mean, again, as a lawyer and a law lecturer, and in watching the entire proceedings, do you see some bit of holes in some of the presentations coming from any of the counsels? Holes in the sense that some lapses here and there in the presentation of all the lawyers and all that.
I mean, I can't comment.
But you asked me to push you. You asked me to push you.
Yeah, and you didn't wait for me to say that, as long as it doesn't leave us within the realms of speculation on substantive matters or within the realms of contempt.
But this is not contempt, neither is it speculation or whatever.
You never know. Subjective.
Okay. All right. Okay. Well, leave it here. Thank you very much, and we wish you all the best. We'll talk to you again as we're going to talk to you. You too. You just heard from Dr. Kwaku Anin Yeboah, who is a lawyer, a law lecturer, and the head of Law Center's Gimpa Faculty of Law, for us to have an understanding of what actually happened in courts today. We wish you could read some of your comments, though.
Sure, but I think that we have indications we have to wrap up.
Yeah.
I don't know whether we're going to have a court sitting tomorrow. I am very sure there's going to be some activity at the court, but as to whether it's going to be an open court, for live telecast, I don't really know. But whatever it is, we will be here. If the case is that we are going to court, we'll be here to bring you discussions with our guest lawyer, Dr. Kwaku Anin Yeboah, who has been giving us some very insightful analysis of the case. They're trying not to get into the midst of the matter. Yeah, he's very particular about that.
So thank you very much for making time with us on television, on radio, and on the internet. We're so grateful for your time. And stay with us. We also promise to stay with you. Enjoy the rest of our programs. My name is George Sapo.
And my name is Morris Ogbete. Thank you very much for watching.
Bye-bye.